On April 15th of 2020, James O'Keefe of Project Veritas announced that he was going to be personally suing Twitter over their false and defamatory statements that he was operating multiple accounts that they used as justification to permanently suspend his personal account off of Twitter. I did a video on this on April 19th talking about my initial thoughts on the lawsuit, but right after that video was uploaded, they decided to go ahead and publish the complaint against Twitter, and now we can see exactly what the claims are that they're suing over. We can check out the language, the cause of action, and we can talk about everything about it. That's what this video is. We're going to talk about all of the elements of this claim as written in their document. Now, I'm not going to go through every word of this document. If you want to read the rest of it, click the link down in the description below, and it'll take you to a link or to the page with the full document so you can review all of it yourself. I'm going to hit some main points that I think are really important to talk about in this case. Some good stuff, some hurdles that James O'Keefe will have to overcome, and we're going to talk about how this case will progress in New York under their new anti-SLAPP law and all of that stuff. So let's get into it. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator here on YouTube. If you like that, please hit the subscribe button and the notification bell so you don't miss any videos, okay? You wouldn't want to miss stuff, especially if this is right up your alley. On to the complaint. Here it is. This is filed in the Supreme Court of the state of New York. If you don't know, the Supreme Court of New York is actually the lower court. It is not the highest level court like it is in many states or like it is at the federal level. It is actually a lower level state court, and that is where you start the legal process in New York. So please don't be confused by that. And we're going to talk about New York. It's an interesting choice for the venue of this, sort of, and it may cause some hurdles, which we're going to hit in just a minute. So, summary of the action. This defamation action arises from Twitter's false and defamatory April 15th, 2021 statement concerning Twitter's decision to ban plaintiff James O'Keefe, an investigative journalist followed by over 926,000 Twitter users at the time that he was banned. Twitter's false and defamatory claim was that it removed Mr. O'Keefe because he operated fake accounts as reported by journalists exemplified in figure 1 below. And this is a tweet from Justin Baragona. And it says that he confirmed James O'Keefe's account has been permanently suspended. A Twitter which means spokesperson, tells me per their policy, you can't mislead others on Twitter by operating fake accounts, and you can't artificially amplify or disrupt conversations through the use of multiple accounts. Now, that is the statement that James O'Keefe is suggesting Twitter said about him that is false and defamatory. And notice it's couched in that corporate language. You can't do this, you can't do that. But the implication, if not the explicit statement, is pretty clear. They're accusing James O'Keefe of operating fake accounts and disrupting conversations through the use of multiple accounts, which he says is not true. And it should be noted that it's pretty easy for Twitter to prove this if it were true, right? Like they should be able to, if James O'Keefe is operating multiple fake accounts, they should be able to point to those accounts and point to their information indicating that James O'Keefe is doing that. So it leads me to believe that O'Keefe is telling the truth here because it would be easily disprovable by Twitter that they're lying. They could just say, we're not lying. Here you go. Here's the data. You asked for it. So that's an interesting element of this case is that James O'Keefe is very confident that this is not happening. Not that I thought that it was happening. It's just, it's a pretty bold claim of Twitter to make. And that, of course, just plays into the audacity of big tech right now and how they act, especially in regards to social media. These guys feel that they're untouchable. They can do and say whatever they want. They believe that because of Section 230, and they believe that because basically politicians all need Twitter and Facebook and these other social media companies to survive and to get elected. At least in their heads they do. And that is a big, big problem with all of this, is just how much leeway these companies have been given because of the implied threat to the people who would make rules around their use. Okay. Twitter's published claim that Mr. O'Keefe operated fake accounts is patently and demonstrably false. Patently in legal terminology means upfront, without further information needed, like on... I don't want to say on its face because that's prima facie, but it means without further investigation. You know it's false. It's false from the onset. You don't need nuance. You don't need extra stuff to figure out. It just didn't happen. And it's demonstrably false because they can't produce a fake account that James O'Keefe allegedly used, right? So that's a big problem for them. Now, here's where we come into an issue. The parties here are plaintiff James O'Keefe is a natural person residing in New York State. So he lives in New York. So that makes sense for him to bring the action in New York. But Twitter is a privately owned Delaware corporation that operates social media publication Twitter.com, having a place of business at 245 West 17th Street in Manhattan. A place of business is not a principal place of business. And this is a problem for this lawsuit. They may try to remove this to federal court because we have a diversity of citizenship here. James O'Keefe is a natural person residing in New York State, so his citizenship is in New York State. Twitter is a Delaware corporation, so their citizenship is in Delaware, but also their principal place of business is in San Francisco. So they're also a resident of California. Neither of those is New York. Now, New York may have jurisdiction over Twitter as they have an office there, having a place of business in Manhattan. New York may actually have jurisdiction over them. However, we have diversity of citizenship between these two parties, and that is potentially a problem here where this could get removed to federal court, and they could have a very expensive and drawn out fight over this, over the citizenship question. And that fight itself could take months or even up to a year, or I guess technically it could take longer, but we'll probably see something from Twitter to remove this to federal court, unless Twitter wants to invoke New York's anti-SLAPP statute. And if that might be sort of the bait to keep them in New York, because if Twitter decides to go ahead and accept jurisdiction and file an anti-SLAPP and they're able to overcome the anti-SLAPP, well, then they have jurisdiction then. Like Twitter's going ahead and saying, okay. So that might be the bait on the hook, so to speak, because they're very confident that they can pass New York's anti-SLAPP law. And if that's the case, that's a pretty good move. I don't know if, who knows? Who knows what course Twitter will take? And that's kind of the gamble that you have in this. Now, James talks about two other accounts that he was associated with, though he did not operate. And that was the Project Veritas official account and the Project Veritas Action official account. Two separate legal entities, two separate Twitter accounts. Both of them were suspended earlier this year, back in February. Those were suspended, and I've skipped a bunch that he talks about them because it's not really relevant to the case, other than to know that they both existed and they're both for separate legal entities, and that James will go on to claim he was not the person tweeting from those accounts. He may have participated in crafting the tweets or reviewing them, but he's not the one who actually sent them out. So those accounts were not operated by James O'Keefe, is what he's saying. Now, here's why Project Veritas' official account was removed. On February 11th, 2021, Project Veritas published a video showing Veritas reporters seeking to interview Facebook Vice President Guy Rosen outside a residence. This video was then published on Project Veritas' Twitter account. The same day, Twitter suspended the official Project Veritas account, claiming Guy Rosen video tweet violated Twitter's policy prohibiting the publication of private information. Now, presumably, they're talking about that being because they went up to the front door of this person and that front door is on video. I don't actually like that practice. I like Project Veritas, but I'm not a big fan of that practice. However, that is in no way a violation of Twitter's policy. And how do we know it? Because major news organizations do it all the time, including CNN, including local news organizations. In fact, I was just talking about how much I didn't like some other journalist doing this to a paramedic who had donated $10 to Kyle Rittenhouse. They had a picture of his front door, and they're there at the address. And I'm not a big fan of that going up on social media. It's just my personal preference. There's nothing illegal about it, to be very clear. And it clearly doesn't violate Twitter's policies when the right person does it, right? Like CNN or some blue check journalist or whatever. Indeed, CNN has done the same thing on a video tweet with over 2.2 million views in which CNN reporter Drew Griffin confronted a private individual. And this is just a random person, not a Facebook spokesperson. So that account was banned, the Project Veritas account. And then only days later, Twitter then permanently suspended Project Veritas Action's Twitter account without warning, claiming the account was created to improperly attempt to get around the Project Veritas permanent suspension. Project Veritas Action is a separate legal entity from Project Veritas and maintained a separate Twitter account for years to publish its own content. Once again, Twitter refused to speak to Project Veritas about the suspension or the reason for it. So we have separate accounts, and this is Twitter's murky ban evasion policy. But these murky policies benefit these social media companies when they're crafted in such a way that they get discretion over who gets to be on the platform. And you should take into account for all this stuff about, oh, they can let whoever they want on their platform or however they're doing it. Kind of. I mean, they are entering into a contract with you when you click the accept button. It's not just you entering into the contract. Twitter is also entering into that contract and saying, we agree to allow you to use these services so long as you follow the rules. Well, if the rules are meaningless, then that contract is worthless and it's a misrepresentation to the people who are using it. And they are taking your data. Twitter makes money off of your use of the platform. They're using your data, they're selling your data to other parties, and they're doing so out in the open. So your contractual exchange is giving them that data. So if they're doing that, if they're just removing us from platforms because of their whimsy, they have taken our data and not fulfilled their agreement to the bargain. That's only if we're not actually breaking the rules. So they make the rules as murky as possible and say they can remove someone for whatever reason that they want. That's not entirely true, and it's just waiting for the right person to test it. But that's a separate discussion. Let's go back to the case here. The very same day Project Veritas did another video on CNN, exposing CNN, and James O'Keefe personally tweeted a link to where you could find those videos from Project Veritas. So the same day that he did that, which was April 15th, Mr. O'Keefe's personal Twitter account was abruptly and permanently suspended without providing him any warning or any prior notice. And that's how Twitter does it. I mean, really, that's just the way they do suspensions. After suspending Mr. O'Keefe's personal Twitter account on April 15th, Twitter, through an unnamed spokesperson, disseminated to media outlets the provably false statement that Mr. O'Keefe was operating fake Twitter accounts. See example given Katie Robertson. Twitter bans the account of James O'Keefe, the founder of Project Veritas, and that's from a New York Times article. Notably, Twitter made these public statements to third parties more than half an hour before communicating this information to Mr. O'Keefe. So they went ahead and did the banning and talked to these journalists from other organizations before the email got to Mr. O'Keefe. And so that is a pretty big deal because they don't get to then claim that he disseminated the information as to why he was banned, that it's him. This was something I was confused about yesterday, was how did Twitter actually publish this statement? But several media outlets reported the same thing, that a Twitter spokesperson informed them, or someone they knew, right? The way that journalists reinforce their own writing, informed them that James O'Keefe was operating multiple fake accounts, and that is a false statement according to him. Twitter's claims that Mr. O'Keefe had misled others on Twitter by operating fake accounts is false and defamatory. All right, so now we have fake accounts policy and enforcement. This is the backstory, the lore behind the Twitter fake accounts policy. The false accusation that Mr. O'Keefe operated fake accounts is particularly damaging for Mr. O'Keefe because Mr. O'Keefe is a journalist. As such, his reputation for transparency and accurate reporting is fundamental to his profession. By accusing him of operating fake accounts, Twitter was directly attacking his fitness for his profession by accusing him of misleading others and by effectively running a disinformation outlet akin to the much discussed Russian interference disinformation bots that plagued the 2016 election and which inspired some political operatives to engage in similar tactics in 2017. Now, Let me point to some specific language here. He's saying directly attacking Mr. O'Keefe's fitness for his profession. This is not explicitly stated in the lawsuit, but it's hinted at. They're getting to an element of, or an aspect of defamation law called defamation per se. Now, defamation per se is when you accuse somebody of some false thing and you implicate them either morally or professionally to such a level that on the face of the accusation, it is damaging. So you don't have to allege any specific damages at the onset. You'll have to prove damages to get an award back. But the accusations are so inherently damaging to the person, either morally or professionally, that the court should presume that these statements did in fact cause harm. Now, James O'Keefe is a journalist who says his integrity and his transparency are critical to his reputation as a journalist, and I agree with that. And so by saying that this is attacking his ability to do his job, his fitness for his profession, by doing that, they are damaging him straight out the gate. And you don't need to prove any specific damages at the early stages because it's obvious how that's damaging to a journalist. So they don't ever specifically call out defamation per se, but they go ahead and lead the court to the trough and let them drink a couple times. Indeed, Twitter's entire fake accounts policy, which it accused Mr. O'Keefe of violating by stating that he operated fake accounts, stems from the Russian disinformation campaign. So he's also letting the court see that they're comparing him to a Russian disinformation campaign, obviously inherently damaging stuff for someone who is in the practice of journalism. So Twitter knew its claim was false and or recklessly disregarded the truth. This is a critical element of the defamation claim because James O'Keefe is almost guaranteed to be a public figure. Certainly when discussing matters of public concern that he is talking about, like CNN and other news stories that he is referring to. So he is going to be a public figure, and therefore he has to show the higher bar for Twitter, which is that they either knew the statements that they made were false or they recklessly disregarded the truth by not taking the reasonable steps to verify the information. As detailed above, Twitter controls and operates its own platform and necessarily has the means and ability to confirm if an individual is operating multiple accounts under aliases and to authenticate the identity of those who open accounts. And as set forth in the publications quoted, Twitter does so on a regular basis. Now, I'm not going to go through most of this section, but it basically talks about how Twitter could possibly know about it. And that should be pretty obvious, right? Twitter runs the platform. They have IP addresses. They have all sorts of metadata that they gather. They have all sorts of personal data that they've gathered based on your practices. And they should be able to meld those together to come up with something. They also have incorporated verification practices like identity verification, phone number verifications, and stuff like that that are used to specifically weed out those false accounts. So since they have all that and none of that applies to James O'Keefe, they should know that he's not operating those fake accounts is sort of the idea there. We don't really need to go through it. Now, this is the claim for relief, defamation. On April 15th, 2021, Twitter, through its spokesperson, published false statements to multiple third parties accusing Mr. O'Keefe of operating fake Twitter accounts. Twitter statements are provably false because Mr. O'Keefe has never operated fake Twitter accounts. And before Twitter gets to hide behind the idea that their spokesman made the statement and that wasn't the official statement of Twitter, I mean, they also sent that as the reason to Project Veritas why their account was removed. So it's not like someone said one thing and they implemented a different policy when they sent it to them and they could kind of make some distance between them and their spokesperson. This spokesperson was accurate with Twitter's statements. So Twitter's statements were and continue to be published without adequate investigation or inquiry first being made to determine their truthfulness. Twitter acted with intent to injure Mr. O'Keefe's good name and reputation. Twitter acted in a grossly irresponsible manner without due consideration for the standards of information gathering and dissemination ordinarily followed by responsible parties. That's a call out to that reckless disregard for the truth. That is the higher bar. They were grossly irresponsible. Responsible parties would have easily investigated and found this out if they were similarly situated to Twitter. Twitter statements wrongfully and unlawfully place Mr. O'Keefe in a false, misleading, and damaging light in the eyes of the public and of potential employers. This is a false light element. It's not a defamation element, but they kind of run next to each other, so you might as well throw that in there. Here is the defamatory element. The false statements subject Mr. O'Keefe to hatred, contempt, and ridicule, tend to diminish the esteem, respect, goodwill, or confidence in which Mr. O'Keefe is held. So false statements that don't cause someone to be ridiculed or held in lower esteem aren't actionable. Like if I falsely claim that you're the greatest person on earth and you gave me $10,000, like, oh, this guy's so awesome, he gave me 10 grand. Like that doesn't harm your reputation specifically. You'd have to have some other steps going through to do that. And you'd have to go farther to prove that I somehow was maliciously saying it. But anyway, typically speaking, the statements have to, by themselves, absent too much extra context, have to go ahead and diminish your reputation. They have to hurt you. Twitter's false statements also excite adverse, derogatory, or unpleasant feelings or opinions against Mr. O'Keefe. Twitter statements further falsely ascribe to Mr. O'Keefe's characteristics or condition incompatible with the proper conduct of his lawful business, trade, and profession as an investigative journalist. Again, going back to that defamation per se stuff I was talking about earlier. Accusing Mr. O'Keefe of misleading his readership by using fake or fraudulent Twitter accounts is extremely damaging to his reputation and imputes general disqualification to do his job as an investigative journalist by lowering the credibility of his reporting and general reputation for veracity. And all the damage suffered by Mr. O'Keefe was completely foreseeable on Twitter's part and, upon information belief, was intended by them or came about as a result of their malicious, reckless, and negligent conduct. Okay, so that is the case here. This is from the Dillon Law Group. That is Harmeet Dillon. She was the person who represented James Damore in the Google lawsuit. It's a very competent law firm. You can find some of these people on Twitter. Harmeet and Ron Coleman are both on Twitter for sure. I'm guessing the other people are too, but I don't know off the top of my head. But a very competent law firm has taken the case that has fought with some of the biggest names in big tech. And so this will be very, very interesting to watch. Let's talk a little bit about this. The main hurdles that they face in this are the jurisdictional hurdle. And then, of course, if they keep it in New York, the anti-SLAPP hurdle. Twitter has a right to say some level of things, and anti-SLAPP laws protect those things. So what they have to do is make a prima facie showing that they have met all of the elements for defamation here in the complaint with what they've done. Now, they're targeting one statement from one spokesperson, allegedly. We don't actually know. And so the elements don't need to be super complicated. Did Twitter make the statement? Yes, through a spokesperson. They've got two different sources listed in here that show that quotation from a spokesperson. Was the statement a statement of fact or a statement of opinion? Operating fake accounts doesn't sound like a statement of opinion to me. Sounds like a fact statement. But one of the problems that they've got is it is couched in a little bit of weaselly language. They didn't say Mr. O'Keefe was operating these fake accounts necessarily. They said, you can't operate these fake. Well, why would he be suspended? You can't operate fake accounts and mislead people, blah, blah, blah. So that's not a huge hurdle to overcome, but we should recognize that it is a little bit of one that they'll have to explain that through the obvious implication. This is clearly the intent of the statement to allow the listener or consumer of the statement to infer directly that he was doing this thing. Then they have to go ahead and prove. So they have to prove that Twitter made the statement. They have to prove that the statement was a statement of fact, not opinion, and that it was a clear statement of fact. They also have to prove that the statement was damaging to Mr. O'Keefe. They've alleged that pretty clearly. They've also set up this idea of per se defamatory statements because it's attacking him in his trade and profession, and it's geared to attack him in his trade and profession. And then finally, they have to show the requisite level of fault for Twitter, which is normally a negligence standard. They negligently spread false information. However, because James O'Keefe is very likely a public figure, they will make the claim that they did this with actual malice, which is either knowledge of the falsity or reckless disregard for the truth. And that reckless disregard and knowledge of the falsity are clearly laid out here. They said, as the entity who controls all of these accounts, they know what accounts are fake and what aren't. So they would know that he's not operating fake accounts. And the reckless disregard element, as a backup, they said, look, anyone in Twitter's shoes with their resources and the access to the information that they have would know and be able to easily find out this information. So if Twitter didn't do it knowingly, they must have done it without ever desiring to know. They recklessly just stated it without doing any sort of diligence or research on it. So that is the elements that, those are the elements, I should say, that exist for defamation. They've laid them out pretty clearly in this very concise, well-written brief, and we should see what happens. Again, the first hurdle, though, is that jurisdiction. Can this be heard in New York? Will Twitter try to remove it to federal court? If they do try to remove it to federal court, they likely lose their anti-slap protection because most federal courts have not applied anti-slaps. Those are state measures. So we'll see what happens there. It's sort of a catch-22 for Twitter. They either have to submit themselves to New York jurisdiction or they have to lose their anti-slap. And Twitter's decision will be the deciding factor there to see how that goes. And then once it goes, if it goes to federal court, we'll have to see if they're able to bring it back to state court. But it looks like there is complete diversity of the parties, so hard to say on that one. And with that, guys, that's the end of the video. Let me know what you think down in the comments below. Tell me about Project Veritas. I hope you found this video very informative. If you did, please share it around. Thank you so much for watching. Until next time, peace. Peace.